I know what it feels like to trust the wrong person with your own name. 2 months ago, I found out that someone I knew, someone I had welcomed into my home, had forged my signature on a deed transfer. She took my lake property, 4 acres of shoreline my family had owned for 40 years. And then she had the nerve to invite me to her housewarming. She actually handed me an invitation with a smile and said she hoped I could make it, as if I was supposed to celebrate the theft of my own land. Her name was Margaret. I had known her for 7 years. She was a neighbor, a friend, someone I had helped when her husband died. I trusted her with a spare key to my house, with my mail when I traveled, with my name on a card that said happy birthday. That same name she forged onto a quitclaim deed transferring my lake property to herself. The land had been in my family since 1967. My grandfather built the cabin with his own hands, and Margaret took it with a pen stroke. The central question is not why someone would do this. The central question is how she got away with it for 6 months, and what happened when I decided to fight back. I first noticed something was wrong in late September. A letter from the county assessor's office arrived, addressed to me but referencing a property I had not sold or transferred. The letter said the deed had been updated, a new owner on record. I opened my filing cabinet, pulled out the original deed my grandfather had signed over to me in 1995, and drove to the county recorder's office. The clerk pulled up the file. There it was, a quitclaim deed dated March 12th with my signature on the grantor line. Only it wasn't my signature. I had never seen that document before in my life. The notary stamp was from a woman I didn't know, and the recording fee had been paid in cash. I stood at the counter and read the document 3 times trying to find an explanation that made sense. The grantee was Margaret H., the neighbor I had trusted with my spare key. I called her that same afternoon. I kept my voice even the way I had learned to do in years of construction disputes. I said, "Margaret, I need to talk to you about the lake property." She paused. Then she said, "Oh, I was going to call you. I hope you didn't get upset about the housewarming invitation. I meant it genuinely. I want you to be part of this." I asked her if she understood that she had taken my land. She laughed. She said the property had been in her family originally. She had a genealogical document, a 1940s deed, proving her grandmother had once owned the lot. She said it was a mistake that my grandfather ever bought it, and she had simply corrected the record. She told me not to worry, that she would make it right by letting me use the cabin whenever I wanted. I hung up and sat in my truck for 10 minutes. The next morning, I called a real estate attorney. Her name was Diane. I told her the whole story, and she asked me to bring the forged deed, the county record, any correspondence with Margaret. She reviewed everything, and then she told me something I didn't want to hear. She said a forged deed is void. In legal terms, it never transfers title. But the problem is that the forged deed sits in the public record, clouding the chain of title. Until a court formally removes it, the property cannot be sold, refinanced, or insured. And the process to remove it, a quiet title action, takes months and costs thousands of dollars. She said the first step was to file a complaint with the county district attorney's office. Forgery is a felony in this state, carrying up to 10 years in prison. But she warned me that district attorneys are busy, and property forgery cases often get deprioritized unless the victim pushes hard. I pushed. I spent 3 weeks gathering evidence. I found the original 1967 deed from my grandfather's purchase. I found my own 1995 transfer deed. I found tax records showing I had paid property taxes every year for 3 decades. I found photographs of me standing in front of the cabin with my father in 1982. I compiled a notarized affidavit stating that I had never signed the quitclaim deed. Diane submitted it to the DA's office. And then I waited. 6 weeks went by. No charges filed. I called the DA's office and was told the case was under review. I called again 2 weeks later. Same answer. Meanwhile, Margaret started renovations on the cabin. I drove past one Saturday and saw a dumpster in the driveway, a crew pulling out my grandfather's old kitchen cabinets. I parked across the road and watched them haul away 70 years of family history. I didn't call the police because Diane had told me not to. It would complicate the quiet title action. but I couldn't stop watching. The turning point came in early December. Margaret filed a counterclaim in civil court. She claimed that I had given her the property as a gift, that I had told her repeatedly over the years she could have it when I was done with it. She produced a handwritten note, allegedly from me, saying, "Margaret, the lake place is yours whenever you want it." The handwriting was close to mine, but not exact. She had forged that too. Diane called me into her office and laid out the options. A quiet title action could take a year or more, and Margaret's counterclaim meant a trial. Diane said the cost could exceed $40,000. I felt the weight of it. I was 59, living on a fixed retirement income. I had the savings from 30 years of contracting, but that money was supposed to be for my kids, for my own future. I asked Diane if we could win. She said yes, but that nothing was certain in front of a judge who might sympathize with an elderly widow claiming a gift. Then Diane said something that stopped me cold. "There's one other avenue," she said. "We can file a motion for preliminary injunction to stop her from altering the property further, but we need to prove irreparable harm, that the property's character is being destroyed while we wait." I thought about the cabinets in the dumpster. I thought about the foundation my grandfather had poured. I told Diane to file the motion. She did. The hearing was set for January 17th. That was the morning everything changed. January 17th. I arrived at the county courthouse at 8:15 in the morning. The hearing was scheduled for 9:00. I had worn my best jacket, the one I kept for funerals and weddings, and I had shaved that morning, which I don't normally do. Diane met me in the hallway outside the courtroom. She looked calm, but I had known her long enough to recognize the tightness in her jaw. She told me the judge was a man named Harrison, appointed to the bench 6 years ago, known for being thorough and impatient with procedural delays. She said that was good for us because our case was clean. But she also said that Margaret had hired an attorney, a woman named Kavanaugh, who had a reputation for aggressive cross-examination. We walked into the courtroom. Margaret was already seated at the respondent's table. She looked different than the woman I had known for 7 years. Her hair was recently colored, her nails done, a dark blue blazer that I had never seen before. She smiled at me. Not a nervous smile, not a guilty smile. A warm, welcoming smile, as if we were old friends meeting for coffee. That smile told me more than any document could. She believed she was going to win. The bailiff called the court to order. Judge Harrison entered, adjusted his glasses, and reviewed the file. He looked at me first. "Mr. Devereaux, I have reviewed your motion for preliminary injunction. You are seeking to prevent the respondent from making further alterations to the property at 1427 Lakeshore Drive pending the outcome of a quiet title action. Is that correct?" Diane stood and confirmed. Then Judge Harrison turned to Margaret's attorney. "Ms. Kavanaugh, your client has filed a counterclaim alleging that the property was a gift. Do you have evidence to support that claim?" Kavanaugh stood. She was a tall woman with silver hair and reading glasses on a chain. She spoke in a measured voice. "Your Honor, my client has a handwritten note from Mr. Devereaux stating that the lake property was hers whenever she wanted it. We also have testimony from 3 witnesses who heard Mr. Devereaux make similar statements on multiple occasions. Additionally, my client has paid property taxes on the property for the past 2 years and has invested over $47,000 in renovations." I felt my stomach drop. 2 years of property taxes, $47,000 in renovations. I looked at Diane. She didn't flinch. She had prepared for this. "Your Honor," Diane said, "the handwritten note is a forgery. We have a preliminary analysis from a forensic document examiner, Dr. Ellen Morse, who compared the note with known samples of Mr. Devereaux's handwriting. She identified 15 points of discrepancy consistent with simulation forgery. We request that the court admit Dr. Morse's report as evidence." Judge Harrison took the report and read it quietly. The room was silent for almost 2 minutes. When he looked up, his face was unreadable. "Ms. Kavanaugh, do you have a rebuttal expert?" Kavanaugh hesitated. "Not at this time, Your Honor. However, we believe the testimony of 3 live witnesses outweighs a paper report." Judge Harrison set the report down. I will take the document analysis under advisement. Let's hear from your witnesses. The first witness was a woman named Patricia, a mutual acquaintance from the neighborhood. She testified that she had heard me say, at a block party in 2019, that I would probably give the lake place to Margaret one day since I never used it anymore. I remembered that block party. I remembered saying something like that, but it had been casual talk, the kind of thing people say over hamburgers and beer, not a legally binding promise. Under cross-examination, Diane forced Patricia to admit she couldn't recall the exact date, had not written down the conversation, and had spoken to Margaret about the case before testifying. The second witness was a man named Carl, a retired electrician who had done work on Margaret's house. He testified that Margaret had told him in 2020 that I had said she could have the cabin. That was hearsay, but in civil proceedings it could still be considered. Diane asked Carl if he had any written documentation. He said no. She asked if he had ever spoken to me directly about the property. He said no. The third witness was Margaret's sister, Linda. She testified that she had been present when I gave Margaret verbal permission to use the cabin in 2021. Diane asked for the exact date. Linda couldn't remember. Diane asked for the location. Linda said it was at a family dinner. Diane asked if I had been drinking. Linda said I had a glass of wine. Diane asked if Margaret had ever produced a signed, notarized document before the alleged gift. Linda said no. After the witnesses, Kavanaugh called Margaret to the stand. Margaret walked up slowly, placed her hand on the Bible, and sat down. She looked directly at the judge and began to speak before Kavanaugh could ask the first question. Your Honor, I want to be clear. I never meant any harm. Tom and I were friends for years. He told me repeatedly that he wanted me to have that property. He said he didn't have the energy to maintain it anymore, and he knew how much I loved it. I took him at his word. The note was just a formality. I never thought it would come to this. Kavanaugh guided her through the story. Margaret claimed that in early March of last year I had handed her a signed quitclaim deed and said, "It's yours. I've already signed it, just get it recorded." She said I had seemed relieved, like a weight was lifted. She said she had the deed notarized by a friend, a woman named Sandra who had seen me sign it. My blood went cold. Sandra was a notary I had used once 5 years earlier for a power of attorney document. I knew her face. I had never signed a deed in front of her. Judge Harrison asked Margaret directly, "Did Mr. Devereaux sign the deed in your presence?" Margaret said, "Yes, Your Honor, at my kitchen table. Sandra was there. She watched him sign it." Judge Harrison turned to Diane. "Counsel, do you wish to call the notary?" Diane said, "Yes, Your Honor, but we have been unable to locate Sandra Wallace. She appears to have moved out of state 3 months ago." The courtroom went quiet. I could feel the shift. The missing notary was a problem. Without her testimony, it was my word against Margaret's and 3 witnesses who had heard me talk about giving her the property. Judge Harrison said he would take the matter under advisement and issue a ruling within 30 days. He denied the motion for preliminary injunction, saying there was insufficient evidence of irreparable harm since renovations had already occurred. He ordered both parties to maintain the status quo, no further renovations, no sale of the property until the full trial. I walked out of the courthouse into a cold January wind. Diane was quiet beside me. Finally, she said, "We need to find Sandra Wallace. If she testifies that she never saw you sign, we win. If she doesn't, it's going to be very hard." I asked how we could find her. Diane said, "We hire a private investigator." That cost another $5,000. I was now $12,000 into this fight, and I hadn't even gotten to trial. The investigator worked for 3 weeks. He traced Sandra Wallace to a small town in Arkansas, found her living in a mobile home park, and spoke to her on the phone. She told him she remembered notarizing a document for Margaret, but that she had not actually seen me sign it. Margaret had brought the deed to her already signed and said I had been in a hurry. Sandra had notarized it anyway, violating state law. She was afraid of being charged herself. The investigator recorded the call. When we played it for Diane, she smiled for the first time in weeks. "This changes everything," she said, "but we need to get her to testify in person." That's when things got worse. A week later, Sandra Wallace died of a heart attack. She was 68. There would be no testimony. The only evidence we had was the recorded phone call, which was hearsay and likely inadmissible. The pivot came from an unexpected direction. My daughter, my adult daughter who lived in another state, called me after I had told her the story. She said, "Dad, check your credit card statements from last March. You were in Florida for 2 weeks. You couldn't have been at Margaret's kitchen table signing anything." I pulled out the statements. I had flown to Fort Myers on March 5th and returned March 19th. The forged deed was dated March 12th. I was 1,200 miles away. I called Diane. She filed a supplemental motion with the credit card statements, flight itineraries, and hotel receipts. The hearing on that motion was set for March 15th. That morning, I walked into the courtroom with a folder full of proof that I could not have signed a document in Kentucky on March 12th. Margaret was there. Her attorney looked pale. Judge Harrison reviewed the evidence. He looked at Margaret. "Ms. Kavanaugh, your client has claimed Mr. Devereaux signed this deed in her kitchen on March 12th. The documentary evidence shows he was in Florida. How do you explain this?" Kavanaugh stood. She asked for a recess to consult with her client. The recess lasted an hour. When they returned, Kavanaugh announced that Margaret was withdrawing her counterclaim and would stipulate to the quiet title action. She said Margaret had misremembered the date. Judge Harrison accepted the stipulation. He ordered the forged deed removed from the public record and awarded me $23,000 in attorney's fees and costs. But there was still the question of criminal charges. The district attorney had declined to prosecute earlier, citing insufficient evidence. Now the evidence was clear. I went to the DA's office the next morning and handed them the entire file. They reopened the case. That was the end of the civil fight. But the story does not end there, because while I had won back my land, I had lost something else that I hadn't realized until it was gone. The trust I had in people. The comfort of living in a small town where everyone knew each other. Margaret sent me a letter, hand-delivered to my mailbox 3 days after the hearing. She said she was sorry. She said she had never meant to hurt me. She said she had just wanted the cabin so badly that she convinced herself it was okay. She signed it, "Your friend Margaret." I burned the letter in my fireplace, but the ashes didn't make me feel any better. The district attorney charged Margaret with second-degree forgery, a Class D felony in Kentucky, carrying up to 5 years in prison. She was arraigned in April. I attended the hearing. She stood before the judge in handcuffs, wearing the same blue blazer from the civil hearing. Her attorney asked for a low bond, citing her age and lack of criminal history. The judge set bond at $10,000. She posted it that afternoon. As she left the courthouse, she walked past me. She stopped. She looked at me and I saw something in her eyes that I had never seen before. It wasn't remorse, it was fear. "I'm sorry, Tom," she whispered. "I didn't think it would go this far." I didn't answer. I didn't have words. I just turned and walked away. That was 4 months ago. The criminal case is still pending, delayed by procedural motions. Margaret is free on bond. She still lives in the same neighborhood. I drive past her house sometimes when I go to the grocery store. I still feel the weight of what she did. Not just the financial loss, not just the legal battle, but the betrayal. I had helped her when her husband died. I had brought her casseroles, fixed her porch steps, listened to her talk about her daughter. And she had taken my grandfather's cabin and tried to make it hers. But something else happened in the middle of all this, something that changed the way I see myself. I had spent my whole life fixing things. I was a contractor. I knew how to rebuild. But I had never had to rebuild myself. After the civil case ended, I drove to the lake property for the first time in months. The dumpster was gone. The cabin stood empty, my grandfather's cabinets replaced with cheap particle board. I walked through the rooms, counting the damage. $15,000 in renovations I would have to undo. But as I stood on the back porch looking at the water, I realized something. The land was still there. The trees were still there. The lake was still there. The cabin was just wood and nails. I could rebuild it. I had rebuilt worse things. I am 59 years old. I have gray hair and a full beard and a calm face that hides what I feel, but I learned something in that fight. I learned that the law is slow, but it can work if you push hard enough. I learned that family, blood, or chosen is the only thing that holds when the ground shifts. And I learned that you cannot outrun a forgery. The truth does not stay buried. Eventually, the paper catches up to you. The criminal trial is set for October. I will testify. I will say that I did not sign that deed. I will say that Margaret forged my name. And I will say that I once considered her a friend. That is the hardest part, because when someone you trust betrays you, it is not just the property you lose. It is the version of yourself that believed in that trust. I am still learning to live with that. But I have the cabin. I have my family. And I have a quiet certainty that what Margaret did was wrong and that the law will eventually say so. That is enough for now. That is enough to keep me going. But that reflective peace lasted exactly 3 days. On the fourth morning, my investigator called with news that turned everything I thought I knew on its head. He had been digging deeper into Margaret's past, running title searches on other properties in the county. He found something. In 2018, Margaret had attempted a similar transfer on a small lot owned by a widow named Evelyn Cross. Evelyn had died before the deed could be recorded and the property passed to her son, who never discovered the attempted forgery. But the paperwork existed. Margaret had forged Evelyn's signature on a quitclaim deed, just like mine, using the same notary, Sandra Wallace. I was not her first target. I drove straight to Diane's office with the new information. She read the documents, then looked up at me with an expression I hadn't seen before. "This changes the criminal case significantly," she said. "Pattern evidence. It shows intent, not a one-time mistake. The DA will have to take this seriously." She called the prosecutor that afternoon. The prosecutor, a man named Keller, had been lukewarm on the case, treating it as a civil dispute that had spilled over. But the Evelyn Cross connection changed his tone. He told Diane he would request a grand jury indictment for 2 counts of forgery, one for each victim. But Margaret did not wait quietly. She had her own attorney file a motion to dismiss the criminal charges, arguing that the 6-year statute of limitations had passed for the Evelyn Cross forgery and that my case was tainted by the civil settlement. She also filed a harassment complaint against me, claiming I had been driving past her house repeatedly and taking photographs. That was true. I had been taking photos of the cabin renovations, but I had never photographed her house or her person. The complaint was a smokescreen designed to make me look like the aggressor. It worked on a small scale. The local newspaper picked up the story, framing it as a neighbor dispute rather than a felony forgery case. I started getting side-eye at the grocery store. Then the real bombshell dropped. 2 weeks before the grand jury was set to convene, Margaret's attorney produced a new document. It was a letter dated March 10th, 2 days before the forged deed, written on my personal letterhead. The letter thanked Margaret for her friendship and stated that I was gifting her the lake property because I could no longer maintain it. The handwriting looked like mine. The signature looked like mine, but I had never written that letter. She had forged another document, and this time she had done it on my own stationery, which she had access to because I had given her a spare key to my house years ago. My blood ran cold, the spare key. I had forgotten about it. I had given her a key in 2017 when I went on a 2-week trip and needed someone to feed my cat. She had kept it. I never asked for it back. She had let herself into my house, found my stationery, and practiced my signature until she could replicate it well enough to fool a layperson, maybe even well enough to fool a jury. I called the locksmith that afternoon and changed every lock in my house, but the damage was done. Diane reviewed the letter and shook her head. "This is going to make the grand jury much harder. They'll see 2 documents, both claiming gift intent. Your alibi for March 12th is solid, but the letter is dated March 10th. You were still in Kentucky that day. You could have signed it." I asked if a forensic examiner could prove the letter was forged the same way they proved the deed was forged. Diane said yes, but it would cost another $5,000 and take 4 weeks. I authorized it. I was now $28,000 into this fight. My retirement savings were hemorrhaging, but I could not let her win. The forensic examiner, Dr. Morse again, took 3 weeks. Her report came back definitive. The letter was a simulation forgery, created by tracing my signature from a legitimate document. She identified 23 points of difference, including pen pressure inconsistencies and tremor patterns that no natural writer produces. The letter had been written with a different type of ink than my personal pen used. Dr. Morse had also found microscopic traces of correction fluid under the signature, suggesting that Margaret had practiced on the page before committing the final forgery. I submitted the report to the prosecutor. He agreed to present it to the grand jury, but then came the second blow. The notary, Sandra Wallace, had not died of natural causes. The investigator's deeper look revealed that Sandra had been under investigation by the state for notary fraud. She had notarized dozens of documents without witnessing signatures for a fee. The heart attack was real, but she had been under extreme stress from the investigation, which Margaret had known about. Margaret had exploited a compromised notary. The ethical lines were blurrier than I had thought. Sandra was not an innocent victim. She was a co-conspirator who had died before she could testify. The grand jury convened in late May. I testified for 3 hours. I told them about the forged deed, the alibi, the phone call, the investigation, the letter. Margaret testified for 2 hours. She claimed that I had given her the property freely, that the letter was real, that the deed was signed in my presence, and that I was only pursuing charges because I regretted the gift after my daughter pressured me. She was calm, composed, and convincing. The grand jury deliberated for a day and a half. Then they returned an indictment on both counts of forgery. I felt relief, but it was short-lived, because 2 days later, Margaret's attorney filed a motion to change venue, arguing that I had saturated the local media with my version of events. The motion was granted. The trial would be moved to a neighboring county, where I knew no one and where the jury pool would be unfamiliar with the case. That meant I would have to explain everything from scratch to 12 strangers who had never heard of Tom Devereaux or the lake property. The new trial date was set for October 12th. That was 8 months after I first discovered the forgery. 8 months of legal fees, stress, sleepless nights, and watching my savings drain away. 8 months of driving past the cabin and seeing the cheap renovations, reminders that someone had tried to steal my history. But I had something Margaret didn't have. I had the truth. And I had a piece of paper that proved I was 1,200 miles away when she claimed I signed. But the worst was yet to come. In early June, I received a certified letter from the county tax assessor. The property taxes on the lake lot were past due. Margaret had not paid them for 2 years. She had claimed she paid them, as her attorney asserted in court, but the records showed she had only paid the first year. The second year she had let them lapse. Now I owed $4,800 in back taxes plus penalties. I paid them. I had no choice, but it felt like another wound. That same week, I discovered that Margaret had taken out a small loan using the cabin as collateral. A $15,000 loan from a private lender. She had used the forged deed to secure it. The lender had no idea the deed was fraudulent. When the quiet title action nullified the deed, the loan became unsecured. The lender came after me, claiming I was the rightful owner and therefore responsible for the debt. It took Diane's intervention and a court order to get the lender to drop the claim, but it cost another $2,000 in legal fees. The pattern became clear. Margaret was not just a woman who made a desperate mistake. She was a methodical operator who understood the gaps in the system. She knew that a forged deed could sit in the public record for months before anyone noticed. She knew that notaries could be bribed or exploited. She knew that the legal system was slow and expensive, and that most people would give up before it was over. She almost succeeded. She almost broke me. But something shifted in me during that summer. I stopped being just a victim. I started becoming a witness. Other people began coming forward. A woman named Carol, who lived 2 streets over, told me that Margaret had tried to convince her to sign over a strip of her backyard for a driveway. Carol had refused. A man named Frank, who ran a small engine repair shop, said Margaret had tried to get him to sign a false invoice so she could claim insurance money. He had reported her to the police, but nothing came of it. A pattern emerged. Margaret had a history of small-scale fraud, always targeting people who trusted her, always using the same combination of charm and forgery. I compiled all of it. I gave it to the prosecutor. He added it to the case file. At the preliminary hearing in July, the judge ruled that the pattern evidence could be introduced at trial. That was a major victory. The jury would hear not just about my property, but about Evelyn Cross, about Carol, about Frank. Margaret's defense of "I made a mistake" would be harder to sell when the jury heard about her repeated behavior. Then came the moment that changed everything. Margaret's attorney requested a plea deal. The offer was 1 count of forgery in exchange for a guilty plea with a recommended sentence of probation and restitution. No jail time. The prosecutor called me to ask if I would agree. I sat with the phone in my hand and thought about it. 8 months of my life. $32,000 in legal fees. My grandfather's kitchen cabinets in a landfill. Evelyn Cross, who died without knowing someone had tried to steal her land. Carol, who had to install a fence to protect her property line. Frank, who lost sleep over a false invoice. I said no. I told the prosecutor I wanted a trial. I wanted a jury to hear the full story. I wanted Margaret to face the consequences of every lie, not just the one that involved me. The prosecutor was hesitant. Trials are expensive. There's no guarantee of a conviction, but he agreed to proceed. That was the summer I learned what I was made of. Not my patience, not my calm, my stubbornness. I was not going to let her win, not even a little, not even on a plea deal that saved me money. Some things are worth more than money. Some things are worth the fight itself. October 12th. I arrived at the courthouse in the neighboring county at 7:30 in the morning. The sky was gray, the leaves were turning, and I had the same jacket I had worn to the civil hearing, the one for funerals and weddings. My daughter had driven in from out of state. She sat beside me in the front row of the gallery. My son-in-law was there too, and my grandson, who had taken the day off school. I had a row of family behind me. Margaret had no one. She sat alone at the defense table except for her attorney. Her sister Linda was not there, and neither were the witnesses who had testified in the civil case. The jury was seated. 12 people who had never heard of me, never seen the cabin, never met Margaret. They knew nothing about the lake or the forged deed or the housewarming invitation. They were a blank slate. The prosecutor, Keller, gave his opening statement. He laid out the case simply. On March 12th, a quitclaim deed was recorded transferring property from Tom Devereaux to Margaret H. Tom Devereaux was 1,200 miles away in Florida. The signature on the deed was not his. The notary had notarized it without witnessing the signature, and Margaret had then invited the victim to a housewarming at the stolen property. Keller called it the audacity of entitlement. Margaret's attorney gave a different story. She said her client had been given the property as a gift, that the date on the deed was a clerical error, that the alibi was circumstantial. She said Margaret was a lonely widow who had been taken advantage of by a man who changed his mind after promising her the cabin. She painted me as wealthy and heartless, a man who had dangled hope in front of a grieving woman and then snatched it away. I was the first witness. I took the stand and swore to tell the truth. Keller walked me through the timeline. The 1967 deed my grandfather, the 1995 transfer to me, the forged deed, the phone call, the housewarming invitation. I told the jury about the spare key, about Margaret's access to my stationery, about the letter she had forged. I told them about the credit card statements and the flight itinerary. I was calm. I had practiced this in my head for months. Under cross-examination, Margaret's attorney tried to rattle me. She asked if I had ever said the property was Margaret's. I said I had made casual comments but never a legal promise. She asked if I had a history of changing my mind. I said no. She asked if I had ever felt guilty about my success compared to Margaret's struggles. I paused. I felt sorry for her when her husband died. I helped her. I never felt guilty for owning land my grandfather worked for. The attorney pressed. Isn't it true you told her she could have the cabin because you didn't want to maintain it anymore? I said. No, I never said that. If I had, I would have signed a real deed, not a forged one. The next day, Keller called the forensic document examiner, Dr. Morse. She explained simulation forgery, showed the jury side-by-side comparisons of my signature and the forged ones. She pointed to the tremor lines, the pen lifts, the correction fluid residue. She testified that the probability of the deed signature being mine was effectively zero. The jury watched her carefully. I could see them leaning forward. Then Keller called the investigator who had traced the notary, Sandra Wallace. The investigator played the recorded phone call, the one where Sandra admitted she had not witnessed my signature. Even though Sandra was dead, the recording was allowed under a hearsay exception because it was a statement against her own interest. The jury heard Sandra say, "I never saw Tom sign it. Margaret brought it to me already signed." That was the turning point. Margaret testified on the third day. She was composed, dressed in a modest blue dress, her hair neat. She told the jury that I had given her the cabin freely, that she had notarized the deed honestly, that the date mix-up was my fault. But under cross-examination, Keller asked her about the housewarming invitation. "You invited Mr. Devereaux to celebrate the property you claim he gave you." Margaret said yes. "Why would you invite the man you had just taken property from?" Margaret said, "Because I thought he would be happy for me." Keller let the silence hang. "Happy for you? After you had recorded a deed transferring his grandfather's cabin to yourself." Margaret's voice broke. "I thought he meant it." The jury deliberated for 6 hours. They came back with a verdict at 4:47 p.m. on October 15th, guilty on both counts of second-degree forgery. The judge polled the jury. Each one said guilty. Margaret stood still. Her attorney asked for a bench trial on sentencing, which was granted. The sentencing hearing was 3 weeks later. The prosecutor recommended 18 months in prison, citing the pattern of behavior, the impact on multiple victims, and the lack of genuine remorse. Margaret's attorney asked for probation, arguing her age and lack of prior convictions. The judge took 30 minutes to decide. He sentenced Margaret to 12 months in state custody, suspended after she served 90 days, followed by 2 years of supervised probation and full restitution of $47,000. The value of the renovations she had made to the cabin, which I was forced to undo. She was led out of the courtroom in handcuffs. As she passed me, she did not look at me. She kept her eyes on the floor. I felt something I had not expected. Not satisfaction, not victory, but a hollow kind of sadness. This was a woman I had once considered a friend. Now she was a felon, and I was a man who had spent a year fighting to keep what was his. The surprising detail came a week later. My investigator called with one last piece of information. Margaret had not acted alone. Her daughter, who lived in another state, had helped draft the forged letter and coached Margaret on how to avoid detection. The daughter had a criminal record for identity theft in her home state. The DA opened a new investigation. I had not seen that coming. The conspiracy was bigger than one desperate widow. It was a family operation. I went to the cabin the day after the sentencing. The leaves had fallen and the lake was still and gray. I walked through the rooms, measuring what needed to be done. The cheap cabinets would come out. I would rebuild them myself, using the same joinery my grandfather had taught me. The floors would be refinished. The porch would be rebuilt. It would take time and money, but it was mine again. I stood on the back porch and looked at the water. I thought about Margaret, sitting in a cell 60 miles away. I thought about her daughter, who would soon face her own charges. I thought about the jury, 12 strangers who had believed me. And I thought about the housewarming invitation, that audacious moment when Margaret had handed me a piece of paper and smiled, as if the theft was something to celebrate. That moment was the seed of this whole story. It was the clue that she did not see what she had done as wrong. She saw it as her due. That is the thing about forgery. It is not just a crime against property. It is a crime against trust. When you forge someone's name, you are saying that your desire matters more than their reality. You are rewriting history to suit yourself. And when you invite the victim to celebrate, you are revealing that you do not even understand what you have done. I locked the cabin and walked back to my truck. The sun was setting behind the ridge and the orange light caught the water. I had my property back. I had my name back. And I had a year of my life that I would never get back. But I had also learned something. The fight was worth it. Because the alternative, letting her win, letting the forgery stand, would have been a different kind of theft. It would have been the theft of my own willingness to stand up for what was mine. I am 59 years old. I have gray hair and a full beard and a calm face. But inside I am not calm. I'm still angry, I'm still hurt. And I am still grateful for the system that worked, for the people who helped, for the family who stood beside me. The trial is over. The sentence is passed. But the story does not end there. Because every time I drive past Margaret's house, I remember. And every time I walk into the cabin, I remember what almost was lost. That memory is the price of having fought, and I am willing to pay it. I have told this story many times now to friends, to family, to people I meet who ask about the cabin. Each time I tell it, I realize something new. I realize that the forgery was never really about the land. It was about a woman who believed she was entitled to something she had not earned. And it was about me learning that trust, once broken, cannot be restored by a court order. There are thousands of stories like mine. The FBI reported over 9,000 complaints of real estate fraud in 2023 alone, with losses totaling more than $145 million. And those are only the ones that get reported. Most victims never find out. Most forgers never get caught. Most stolen deeds sit in county records for years, undiscovered, poisoning the chain of title until someone tries to sell. The system is slow. It is expensive. And it relies on people like me who refuse to quit. I think about Margaret sometimes, not with anger anymore, but with a kind of weary understanding. She is out of prison now on probation. She still lives in the same neighborhood. I see her car sometimes. We do not speak. I do not know if she understands what she did or if she still believes she was in the right. That is the lingering question that stays with me. When someone forges your name, do they know they are stealing more than property? Do they know they are stealing your sense of safety, your trust in the people around you? The cabin is almost rebuilt now. I put the last cabinet in last weekend, built from the same wood my grandfather used. My grandson helped me with the joinery. My daughter came up and painted the walls. The place looks better than it did before Margaret touched it. But every time I walk through the door, I see the ghost of her renovations, the cheap particle board that had to be torn out. I see what almost was lost. I do not want this story to be a warning, though it is one. I want it to be a reminder that the law can work if you push it. A reminder that family, real family, is the thing that holds when everything else fails. And a reminder that sometimes the most important fight is the one that costs you more than you ever expected to pay. If you have a story like this, if someone has taken something from you and tried to make it theirs, I want you to know that you can fight, you can win, and you can rebuild. It will cost you, but so will silence. My name is Tom DeVero. I am 59 years old. I am a contractor, a grandfather, and a man who learned that a signature is not just ink on paper. It is your word, and your word is worth fighting for. If you made it this far, consider subscribing. Stories like this one need to be heard. And if you have your own story of betrayal or justice, share it in the comments. Because the only way we protect ourselves is by telling each other what we have survived.